By popular demand, today we will revisit and further explore Texas Senate Bill 140, which amended the Texas Deceptive Trade Practices Act to encompass and prohibit many spam text messages sent to Texas residents on or after September 1st, 2025. My name is Chad Cummings, and I am an attorney and a certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the firm Cummings and Cummings Law. I also teach business law at Florida Gulf Coast University and hold 4 degrees, including 2 law degrees, together with a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. If you are a Texas resident and have received unsolicited promotional text messages, whether by iMessage, text, SMS, MMS, WhatsApp, Instagram, or another mobile app, you may have a legal right to compensation. But asserting that right under Texas Senate Bill 140 and federal law is not as simple as filling out a form or lodging a complaint. These are legal claims governed by strict statutory requirements, and missteps can permanently compromise your ability to recover damages. Senate Bill 140, which took effect on September 1st, 2025, further expands the Texas Deceptive Trade Practices Act to include certain types of unwanted digital messaging. Under the amended law, companies that send promotional messages to Texas residents without prior express written consent may, in certain cases, be held liable. That liability can reach up to $1,500 per unwanted message and sometimes even more. But the law does not enforce itself. To secure or at least try to obtain compensation, the recipient must first initiate a formal legal claim, ideally by working with an experienced commercial law attorney. And that claim must be constructed in a way that complies with both state and federal consumer protection statutes, especially the Texas Business and Commerce Code, and in some cases, the Federal Telephone Consumer Protection Act under Title 47 of the United States Code. Filing an informal complaint, sending a casual demand, or relying on generic templates from the internet is not only ineffective, it can be legally dangerous. Improperly worded demand letters can, in certain cases, expose the sender to claims of unlawful coercion, extortion, or even defamation. Incomplete filings can result in the dismissal of an otherwise valid claim, and attempts to backtrack and fix a mishandled demand can often be futile once statutory deadlines pass and the sender's credibility is compromised. What makes compliance so complex is the interplay between multiple layers of regulation. There are specific timing requirements for issuing demand letters, and there are formatting and content obligations under both Texas and federal law. There are also procedural duties related to notice, negotiation windows, and escalation paths. Even minor deviations, particularly those committed by a non-attorney practicing law without a license, can result in claim denial or worse, further open the claimant to counterclaims or regulatory scrutiny. Moreover, Texas law strictly limits who can prepare and transmit legal demand letters. Drafting a demand letter on behalf of another person may constitute the unauthorized practice of law unless the drafter is a licensed Texas attorney. This makes many non-attorney online filing services not only unreliable, but potentially illegal. The risks extend far beyond ineffectiveness. They can also include civil penalties and regulatory enforcement against those who misrepresent their authority to practice law in the state of Texas. In many cases, companies will ignore or reject claims that are self-drafted or that otherwise do not appear to be professionally prepared. And for this reason, informal or vague communications are often not taken seriously. Once a claim has been submitted incorrectly, it becomes much more difficult to remedy. The evidentiary trail becomes muddled, deadlines may lapse, and the other side has more leverage to delay or deny the matter entirely. Compliance in this context is not about filling in the blanks on a form. It is about meeting substantive legal standards. This includes documenting the violation, preserving evidence, drafting a complaint instrument, transmitting it through proper channels, and responding appropriately to counteroffers, denials, or attempts at negotiation. Each step must be handled with precision, ideally by a licensed Texas attorney. There are also risks tied to the use of AI-generated demand letters. Models like ChatGPT, Gemini, and Grok are not attorneys, and the outputs that they generate are not tailored to the specific nuances and complexities of Texas consumer protection law. Many users have unknowingly submitted letters containing language that voids their own claims, misstates the law, or fails to meet statutory requirements. Worse, some of these letters have used threatening, coercive, and extortionate language that may expose the sender to liability for civil and criminal wrongs such as extortion and wire fraud. Filing a claim is a legal act with legal consequences. Those consequences extend not only to whether compensation should be awarded, but also to whether the claimant has exposed themselves to undesired litigation or even criminal charges in extreme cases. This is why proper legal guidance from a Texas attorney is indispensable. In short, and to recapitulate, compliance is not optional. It forms the entire foundation upon which these claims rest, and non-compliance can result in penalties that far exceed the value of the original claim. If you are considering asserting a claim under Texas Senate Bill 140, understand that it is not simply a matter of being right. It is a matter of being procedurally correct, substantively accurate, and legally strategic in partnership with a Texas attorney such as myself. Failure to meet those standards will almost certainly result in lost time, lost money, and potentially lost rights. Before taking any action, especially before sending any written communication to a company or filing anything with a government agency, it is strongly advisable to consult with a licensed Texas attorney who is experienced in this area of law. Doing it right the first time is not just the best option. In many cases, it is the only option for effective resolution. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information contained in this video is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier videos, please visit my firm website at www.cummings.law, not .com, but .law to schedule time for a consultation. If you are interested in potentially pursuing a claim under Senate Bill 140 and the revised and amended Texas Deceptive Trade Practices Act and relevant federal law, you may also wish to visit my custom portal that I have created specifically for this purpose at www.texastexts.law. That's www.texastexts.law, texastexts.law. I look forward to the opportunity to speak with and perhaps even work with you very soon.